Hi, I'm Emily and I am here with Maya Murphy's attorney, Ephraim J. Fink. Attorney Fink practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fink is, I'm having a difficult time deciding who I want to hire as the right lawyer for my personal injury case in Connecticut. What should I be thinking about before I hire an attorney?
Good morning, Emily, and thank you for that question. It may sound cliche, but hiring the right attorney can mean everything. We are inundated with television commercials and bus and highway billboards, internet advertisements, and the like, demonstrating that there's no shortage of personal injury attorneys out there. So finding an attorney you are comfortable with who strikes the right mix of experience and professionalism, compassion, bravado, skill, and even their connections within the legal industry itself, it can be overwhelming. Like in many areas of law practice, an injured client's working relationship with his or her attorney is substantial to maximizing the success and outcome of the personal injury case. Much of the information the attorney will rely on comes directly from the client, so communication is key. Moreover, the interchange of the attorney's explanation of the various applicable laws, the strengths and weaknesses of the claims, and the management of the client's expectations are significant as to whether the attorney-client pairing will prosper and accomplish the goals in mind with respect to what they are seeking for a recovery. So naturally, the matter of an amount of time an attorney has been in practice, I gotta start over on this. Naturally, the amount of time an attorney has been in practice and his trial experience count when looking for the right personal injury lawyer. But so do other life and work experiences. You may want to seek an attorney who previously worked defending the insurance companies from personal injury lawsuits and claims, as they will have an advantage knowing the tricks of the trade when it comes to understanding how the insurance company is evaluating your case. Some attorneys have had a medical background as either a physician or a nurse and may be well adept at understanding complex medical issues and damages, or they may be very well versed in interpreting medical records or deposing doctors. Similarly, some lawyers have specialized knowledge of the construction industry and are highly skilled at identifying where general contractors failed in their duty to safeguard workers. Some clients will also want to hire a larger firm to feel like they've hired a team, whereas some injured persons rather hire a solo practitioner to have the impression that they're getting more personal attention paid to their case. As a personal injury case is ordinarily based on a contingency fee basis, the lawyer only gets compensated if the injured person receives remuneration. It is essential that the attorney-client relationship be confirmed in a signed writing, known as an engagement letter or retainer agreement. The attorney is required, pursuant to Rule of Professional Conduct 1.5c, to ensure that the relationship is reduced to a specific written agreement. I had one client come to me with a very good slip and fall case against Stop and Shop because her prior attorney did nothing for a year and, most unfortunately, did not have a signed retainer agreement in violation of the rules. Most people believe a contingency fee for a personal injury matter is 1/3 of the gross recovery by verdict or settlement, and that is true. While this arrangement is customarily agreed upon in a personal injury contingency matter, engagement letters cover even more than just the attorney's fee. Typically, retainer agreements also include how costs and expenses are to be addressed. Usually the attorney covers these expenses up front. They also address how experts are to be hired, and they also provide direct, express guidance on how the attorney-client relationship may have to be terminated if there is a substantial disagreement on strategy, or each has a different opinion of what the value of the case may be worth. There is a Connecticut statute that provides a sliding scale, which outlines a percentage of the attorney's fee in increments up to $1.2 million. So, for example, if you're following the Connecticut sliding scale, then the attorney would earn the 1/3 or 33% of the first $300,000 of recovery, 25% of recovery in excess between $300,000 and $600,000, 20% between $600,000 and $900,000, and 15% between $900,000 and $1.2 million. Anything above $1.2 million, the statute lowers the fee for the attorney to 10%. However, if the attorney and the client wish to, they can still go with the 1/3 fee for the entire recovery, so long as the agreement spells that out, that they are waiving the statutory sliding scale. It needs to be very explicit. Another rule of professional conduct that is critical to what you should be thinking about is Rule 1.4. This is all about what the attorney owes you in terms of communication, promptness, responsiveness, and diligence. The lawyer must, among other things, promptly inform you of any decision or circumstance in which your consent about the issue is required. They must reasonably consult with you about the means in which your objectives are to be achieved. That's discussing strategy. They must keep you reasonably informed about the status of your matter, including telling you of all court appearances, even if you don't have to be with them. This is the big one. They must promptly comply with requests for information. We constantly hear stories about my attorney is not returning my call. My attorney is not responding to my email. There is no hard and fast set rule, but once you climb past the 24 to 48 hour period, the ethics committees tend to think of that as unreasonable on the attorney's part. And they also need to explain a matter to the extent reasonably necessary to permit you to make an informed decision. They need to explain things to you in a way so that you are making a good decision because you have all the options and alternatives laid out in front of you. This is the rule that covers all those stories we hear about. And if your attorney is not returning your phone calls, I will call you back the same day. If your attorney is not responding to your emails, I will respond to you the same day. Please call me at Maya Murphy if you need a personal injury litigation attorney today.